presented by Turistally, functioning of the virtual court during the pandemic.
Universally accepted that unrestricted, honest, and convenient delivery of justice in a nation is very crucial to the functioning of the democracy, as it provides a significant check and balance against the function of the legislature and the executive. The COVID 19 virus appeared with the ferocity of a flame and the suddenness of a pitfall as it spread across the human communities across the world. The pandemic disrupted the justice delivery system like never before. The compulsions related to social distancing connected with lockdown orders led courts and tribunals to close off their premises to the public. At the same time, understanding that a full shutdown of the justice delivery system is unsuitable, judicial administrators bent to technology to meet the challenges extended by the pandemic. So, the virtual court system was carried out of the need for an alternative.
During the pre-COVID period, the virtual court setup was mainly used for performing remand matters to deter movement of prisoners between courts and jails. Legal sanctity was provided to video conferencing by the Supreme Court by a comprehensive order invoking Article 142 of the Constitution of India, passed on 6th April 2020, which covered all the high courts in the country.
In India, the virtual court system was developed under the E-Committee of the Supreme Court chaired by Justice D.Y. Chandrachud. Keeping in mind the pandemic scenario in virtual courts, complaint and other documents are filed electronically through e-filing. Arguments are heard over video conferencing or teleconferencing. The evidence is submitted digitally. Witnesses give their testimony remotely over video conferencing. Court fees or fine is paid online. Justice decide cases online, either presiding from the physical courtroom or sitting in some different place. A copy of the order or judgment is made available on the website of the court or through some electronic means. Scanning and digitalization of case records are also done. Live streaming of virtual hearings takes place, and more helplines and e-Seva Kendras have been provided. The Supreme Court, through its Secretary General Sandeep Kalgaonkar on March 23rd, also notified the usage of video app for enabling hearings through video conferencing.
Apart from laptops and computers, some advocates have also been using iPads and smartphones to log into the hearings. This freedom has enabled them to appear from unusual places. Initially, the priority was given to cases associated with the lockdown, such as issues about migrant workers returning to their home states. Towards the beginning of the pandemic, if the parties felt they had an urgent matter, then an application was to be made asking for it to be taken out of turn. In case of high courts, video conferencing would be the main mode of hearing arguments at the trial stage or the appellate stage, but would not be used to record evidence unless there was consent from both parties in the dispute.
Summary proceedings like bail, injunction, inquiries, the availability of documents, trials of compoundable offences, trials where giving a fine is the only sentence, municipal challans, traffic violation, and easy mediations can all be conducted by video conferencing.
Thus, virtual courts transformed the documentation, evidential and procedural mechanisms and conducted hearings online from start to finish, keeping up with the safety guidelines of the pandemic, primary of which is social distancing.